Greetings. This is Dr. Della Welch, and this will be tape 8, or the conclusion of tort law. And this will be more of the question and answers to help you understand the testable areas in the law of torts. The next question is, if a surgeon had permission to operate on you and take out your diseased appendix, and without your permission decided to take out your gallbladder too, all for the same price, you would have a technical cause of action for battery against the surgeon. And that would be true. If you consented to one surgery, which was the appendix, and he added the other one, the gallbladder, there was no consent to the gallbladder. As a practical matter, the hospitals usually are very much aware of this, and they have you sign a very broad consent to cover this kind of situation, or they have someone in the family that may be able to give consent for you if you're under surgery. So that tests the defense of consent. Okay, the next question. Contributory negligence can be defined as A, an allegation plaintiff must make in his or her declaration, B, a defense used by the defendant against the plaintiff, C, the same as assumption of risk, D, none of the above. The correct answer is B. Contributory negligence is a defense used by the defendant against the plaintiff. So suppose the plaintiff is suing the defendant for causing an accident and going 100 miles an hour. Well, the defendant says, as a defense, well, I may have been going 100 miles an hour, but you were on the wrong side of the road. So in California, we have what they call comparative negligence, wherein the negligence is parceled out and your recovery would be reduced by the amount of negligence in which you are found responsible. Now, several states have contributory negligence, so it does depend on the state you're in. Some states, if you're 1% negligent, then you will lose your entire case. So you must check the law of the jurisdiction in which you are located. Next, a homeowner who keeps wild animals on his or her premises will be liable to persons injured by these wild animals on the basis of A, strict liability, B, nuisance, C, contributory negligence, D, act of God. The correct answer is strict liability. So if you keep a pet python on your property and it gets out and it eats the little neighbor boy, well, you're strictly liable, which is absolute liability. If you go to the zoo and there's a big sign, do not pet monkey, but you can't stand it, you want to pet the monkey, and the monkey bites your finger off, well, you've assumed that risk, that they know that the animal is a wild animal, and they have provided warnings. Next, if someone points an unloaded gun at you, even though you did not know the gun was unloaded, the court will find no tort of assault occurred, as there was no possibility of harm. True or false? That would be false. You only have to apprehend that you are about to have an immediate touching. You don't have to be absolutely sure that the gun is loaded. Suppose one of you called me at home and said, the next time I see you at class next week, I'm going to punch you. Well, it wouldn't be anything of an assault or battery right then, I'd have to wait till next week until you did that, because it must be an immediate type of contact. Now the next question is the name of a specific tort involving an intentional attempt to commit physical harm to the plaintiff is A, assault, B, battery, C, conversion, D, none of the above. The correct answer is an assault. An assault is an awareness of an immediate attempted battery. So it must be immediate, and you have to be aware of the attempt to do the intentional physical harm or to do the touching. Next question, the name of a specific tort involving an unauthorized touching of the plaintiff is A, assault, B, battery, C, nuisance, D, none of the above. The correct answer is B, battery, because it is an unauthorized touching of the plaintiff. So it can be, a battery can be a harmful or offensive intentional touching of the person of another without consent or privilege. Suppose your business law class goes on a field trip and one of the ladies is sleeping on the couch and a homeless person comes up and kisses her. Well, it may not have been harmful unless they had AIDS, but it was offensive. The entire class was laughing. So a battery can be a harmful or offensive intentional touching of a person of another. And I gave you a little mnemonic to remember the intentional torts to the person. B is battery, A is assault, F is false imprisonment, and I, intentional infliction of mental distress. And then in terms of torts to land, the mnemonic is TCC. T stands for trespass to land. C stands for trespass to chattel or personal property. That's a minor interference with the personal property of another. Suppose you bring a straw hat to school and I sit on the straw hat. Well, it was a minor interference. I didn't ruin it, so it would be trespass to chattel. Conversion would be the substantial interference with the property of another. That's really a taking. For example, suppose I don't like straw hats. You bring a straw hat to class and I rip up the straw hat. Well, what's happened is I've converted it. I've taken it from you. And so that is important to know. Suppose you bring your dog to school and I don't like dogs and say I shoot at the dog and kill the dog. Well, that would be a conversion. That would be a taking. So you also need to know the torts to reputation, such as slander, which would be a spoken false statement, and libel, which would be a written false statement. Remember that truth is a defense. This is the end of our question and answer in the tort area.